and welcome to this DRBF Region 2 Connection webinar series. Together, Tanner Dedezade, Malith Mendes, and Don Rahukwa, we are looking at the third webinar in this series. We previously talked about dispute avoidance and FIDIC suit and dispute resolution and FIDIC suit. And today, we're going to talk about understanding the engineer's role in dispute avoidance and resolution. I am Georgiana Dekuch, President-elect of the DRBF Board of Directors Region 2, and I am your host for today. For those who are new to DRBF, the Dispute Resolution Board Foundation was established in the 1996 by the creators of the dispute board process with a mission to develop dispute avoidance and effective resolution for construction projects. Today, the association has over 1,200 members from 97 countries, as the dispute board process has expanded worldwide and is now used on a variety of projects and long-term contracts of many types and sizes. The DRBF develops best practices and offers training and educational resources for project owners, contractors, and DB practitioners. It also partners with other industry organizations to adapt the DB process to new sectors. And it may be of interest to note that DRBF is publishing a guide to best practices and procedures, the DB manual, now available in English, French, Spanish, and Portuguese. Today's webinar is really the last one in the series, because I know I promised you last time there will be only 2 parts. But some of you wanted us to expand on the role of the engineer in dispute avoidance and resolution under the FIDIC conditions of contract. So among other things, today we'll look at the role of the engineer during the consultation stage and its different approach between the 99 and 2017 edition, at what 2010 MDB edition brought new to the stage, and the comparison of the engineer's activity during the consultation stage with that of a mediator, and which could be the risks or the advantages of such a comparison, and many others. If you missed our previous 2 sessions, you could log on the DRBF YouTube channel, or if you're a member, you could access the library and view the recordings. You already met them twice, but for those here for the first time, allow me to introduce to you our speakers. Tanner Dedezade is a partner at Howard Kennedy, an international construction barrister, dispute resolver, published author, and world-renowned speaker. He is on the FIDIC President's list of approved dispute adjudicators, a FIDIC certified trainer, and an ICC arbitrator. Tanner has won the FIDIC Trainer of the Year awards in 2020. Malith Mendes is a chartered engineer with 40 years of experience. He sits as an arbitrator, but he's also a FIDIC certified adjudicator, a FIDIC certified trainer, and a member of the FIDIC certified trainer writing and examination committees. He was an examiner during the trainer assessments in 2022 and a reviewer of the 2017 FIDIC contracts. He's the chair of South Asia and Sri Lanka country representative for the Institution of Civil Engineers, UK, and served in many standing and ad hoc dispute adjudication boards, as well as in arbitral tribunals. He is currently the chairman of consulting companies Morocco in Singapore and Mendes Caben Consultants in Sri Lanka. Don Rahukwa is a construction claims advisor in Botswana, focusing on both contentious and non-contentious construction and dispute resolution advisory services. He is the honorary secretary of the Botswana Institute of Arbitrators, an executive committee member of the Construction Adjudication Association of Southern Africa, and an executive committee member of the Botswana Association of Mediators, and a member of Society of Construction Law UK. And now, because from all of us, Malith is the one who has acted as an engineer under all FIDIC editions, I would like to start by asking him if the engineer under the FIDIC conditions of contract has indeed a role of in avoidance of disputes. Malith, if you please.
Thank you, Georgiana. Yes, I mean, the engineer is the first opportunity, has the first opportunity and the role to play in dispute avoidance. it lands at his desk first, for him to decide what action he should take to avoid disputes further down the line. It can be simple things like, failure of materials, test reports being failed, or some defects coming up. And it can go on to extend as far as EC helping and playing his role and engaging with keeping records when a notice of a claim has been submitted by the contractor. So his role starts long before DAB or him acting under 3.5 or subclause 3.5 or 3.7. It starts long before that. He has a key to solving a lot of these problems that a site might have during construction. So for him to be engaged is the most important. I think 2017 contracts, in a way, make sure that gives him opportunity to be more engaged than the contracts before that 2017 contracts. And also ask for his commitment, everyday commitment to ensure that things happen smoothly at site. So the problem for him is to decide what action he should take when a problem does come up, and what instructions he should give, or what advice he should give the parties or the contractor in particular on what action to take. Let's say a material has failed, and it's failed several times. Now, does he advise the contractor maybe it's a good idea to hold work and look into this problem? Let's say you're doing construction of columns, and you do find that you have a concrete failure problem occurring with the 7-day test that you're doing. And then you might have to decide whether to stop construction and look into why the concrete problem is there, that failure of the concrete on the 7-day test. Rather than go on and construct all the columns, then having started on the next slab, you end up with having to remove the slab formwork and then start breaking the columns again. As well as any defects that might appear, in the construction itself, through bad workmanship, or not acceptable workmanship, or proper methods not being adapted. So it starts there, and it goes on to the extent where, as the contract also says, when a notice is received from the contractor to the engineer, a notice of claim, he should, without admitting liability of the employer, engage himself in ensuring that good records are kept. That's half the way towards resolving a dispute and avoiding a dispute, to ensure that all records are kept in such a way that it's comprehensive record, so that a dispute can be avoided, and the contractor might decide not to go ahead with the claim because the records are clear that there was no problem. So those are areas in which an engineer can play the initial role in dispute avoidance. So his role is very, very important. I hope I have given enough evidence of the early role of an engineer in dispute avoidance.
Thank you, Malith. Don, do you have any particular good experiences that you could share with us?
I've probably got more bad experiences than good experiences, but we learn from the bad. Actually, the bad experiences teach you the best lesson very often. The experience that we've had it with a unique problem, and I'm sure Tanner will jump in on this problem of having an engineer who is appointed in-house from the employer. And that tends to put the cat amongst the pigeons, because the credibility of the engineer, unless he can stand his ground and is very independent, it can lead to a situation where from the get-go, the parties are very suspicious about the role that he's playing. Couple that with subclause 1.5 priority of documents of the FIDIC 1999, and the last paragraph says, if any ambiguity or discrepancy is found in the documents, the engineer shall issue any necessary clarification or instruction. That's basically putting on his head a discretion that he has the final word. So to me, the point of a credible engineer normally is involved way at the beginning, and I agree with Malith on that. And the more that he becomes visible to the parties, the more it is easier for him to have a relationship with the parties. So that to me is the most important attribute. Get him in early or her early, and get them to start talking to the parties at a very early stage. And then during this consultative stage, most of the experience that we've had in Botswana is that the engineer jumps very quickly to issuing a 3.5 determination and does not pay enough or sufficient attention to the stage of trying to achieve agreement between the parties. So for now, that's what I'd like to say.
That's quite interesting. Tanner, you may want to kick in on the consultation part and the short versus long, and what's the relevance of time there?
Sure. Thank you for inviting me to our third session. I still remember with great fondness the very first session, which was in Nairobi, where I first met Don, and then how we created the session with all of us with Malice. And now we're here again, once again, third time, or is it fourth time lucky? So going to your question about the consultation and how that should work. So let's before I talk about that consultation, I just want to pick up one of the points that Don made about the role of the engineer and whether or not the engineer is impartial or deemed to act for the employer. And of course, we need to go back in history a little bit. So in the 4th edition of FIDIC, the engineer was impartial. And after the process of the engineer being apparently impartial, and where there were potentially issues with engineers' decisions that could not be resolved in any other way other than arbitration, in the wisdom of FIDIC, they came up with the concept that we may as well say it in terms in the 1999 form, that the engineer is deemed to act for the employer. So where the engineer is deemed to act for the employer, we all know that the engineer is going to be acting on behalf of the employer. But then there are a couple of places in the contract that use the word fair. So then the question that then arises is what is a role of an engineer who is deemed to act for the employer when it comes to fairness? So there are two places in the 1999 form where the word fair is used. The first relates to 3.5 determinations, which we'll go on to deal with it in depth in a few moments. And the second is where the engineer needs to certify. So when a certification happens, the engineer needs to certify what it considers is fairly due to the contractor. Now, how is it that an engineer that's deemed to act for an employer is supposed to give a fair determination? And this is a question I've been asking myself for some time. So years ago, when I first started discussing this topic, I always used to think that the exception to the role of the engineer acting on behalf of the employer was the time when he was making he or she was making a 3.5 determination and giving a fair determination. So it was an exception to acting on behalf of the employer. And then somebody pointed out to me that in the 2000 FIDIC guide to the 1999 forms, that if you wanted it to be the case that the employer was not going to be acting on behalf of the employer whilst issuing a fair determination, there needed to be an amendment made. So the question was, therefore, is it the case that the engineer is in fact acting on behalf of the employer and at the same time giving a fair determination? Now, fast forward to 2017, the way that the 2017 form dealt with it is they made it expressly clear in the first sentence of subclause 3.7, which is the equivalent clause to 3.5 in the 99 book when it talks about determinations. They made it expressly clear in that first sentence of the 2017 form that when the engineer is going to be considering the process of trying to reach an agreement between the parties and then giving a determination, it will be doing so neutrally. So this is a new word that's been introduced. We had impartial in the 87 form. We had fair determination in the 99 form. We've still got fair determination in the 2017 form, but it expressly says in the 2017 form that when the engineer is making its decision, it must do so neutrally and is not acting on behalf of the employer. So framing all of that, now let's go back to consultation. So what Don introduced is the concept of the consultation. And the question that I'd like to kick about here is, under the 1999 form, what it says is that the engineer, in advance of giving a 3.5 determination, needs to consult with the parties with a view to trying to get the parties to reach an agreement. So the question that is silent and the question that's not addressed in the 1999 form is, to what extent should this consultation take place? How should this consultation happen? How long should an engineer take in this consultation process? So, for example, I have experience where, acting for an employer, there was a dispute that the engineer was considering. The claim had been presented by the contractor, and the engineer decided, in order to fulfill its consultation process, to simply write one letter to the employer to say, please, can you give me your position within the next 3 days? And then another letter to the contractor saying, please give me your decision, within 3 days. Give me your opinion on the claim within 3 days. And that's consultation box ticked. So one letter to each party, that constitutes consultation. Now that's at one end of the scale. And on the other end of the scale, I've had consultations that go on literally for more than a year, where the engineer will say, right, I would like you to all come into my office. And the engineer is, I think Malice at one point used the word king of the jungle. The engineer is king of the jungle and is going to ask the parties, because it's got no time frame, no reason for it to make a decision very quickly. And it's going to sit them down and is going to then try and see if there can be an agreement reached over an extended period of time. So the first question that I wanted to explore is, what is the appropriate time frame under the 99 form that an engineer ought to take when engaging in the consultation process? That's the first question that I wanted to raise. And in fact, let's just throw that out. So what do you think, Malice? Let's start with you first of all. Do you think it would be appropriate for an engineer to simply write a letter and 3 days later has completed its consultation process? Or do you think extended meetings would be more appropriate, are either good enough to fulfill the consultation process?
Tana, it's consultation. So it's not writing letters and hoping there'll be some response from the parties. It may start with consultation of either party separately, and then, but then the engineer, when he meets the parties, either separately or later on jointly, must have his own analysis of where the dispute resolution lies, or the dispute resolving lies. So he must be able to show where he stands on that position, and that should be properly analyzed, reasoned with necessary records, to be able to show that he has made a logical, contractually correct, and technically correct proposal of where the solution lies. So consultation shouldn't be just writing letters, but to meet with the parties and explain what is claimed by the contractor, where the employee's position is, and where he thinks the solution should lie. So that can take several rounds of consultation. And remember, in the new 2017 contract, that's 42 days. That's 1.5 months. That's quite a long time for him to be able to do adequate amount of consultation and getting each other's opinion and expressing his opinion on the matter. So idea is to try as best as possible to resolve the claim through consultation. That leads to a statement of agreement, a determination of agreement or statement of agreement by the engineer, which can resolve the problem. So consultation shouldn't be restricted to anything. It should not be said, here's the way we're going to do it. It should be more open, and then engineer also has to show that he's acting as per the new contracts under 3.5, neutrally and not act for the employer, and show his independence of view of where the solution lies. I think that's the important part. So there shouldn't be restrictions on how the consultation should be done. A lot of time, and consultation is very important to ensure that it doesn't lead to further escalation of the dispute.
Okay, so let's
Sorry, if I might, Tanner,
Oh,
if
yes,
I
of
might
course,
just come
Don.
in at this point.
Yeah.
I agree absolutely with what Malith has been saying, but we should not lose sight of the fact that under subclause 20.1 of FIDIC 1999, there is a provision which says within 42 days after receiving the claim or any further particulars supporting a claim, the engineer shall respond with approval or with disapproval and detailed comments. And then at the same time, he may also request any necessary further particulars, but shall nevertheless give his response on the principle of the claim within such time. So that gives us somewhat of a ballpark time within which, if he's given his in principle determination, that's the precursor, or that's the indication of which the parties would then engage in the consultation. So even at that stage, the principles of the claim, although I'm a bit skeptical about how if he, for example, has a limitation on his authority where the employer has said, thou shalt not give an extension of time of above a certain figure, how then he can engage in consultations with the parties when there's a limit on his authority, which has been imposed by the employer and notified to the contractor. Thanks, Tanner.
Well, that sets up a great new ball to discuss, to toss around and throw up in the air and see if we can catch. This 42 days in the 1999 form, I've always found it very confusing. This is subclause 20.1, as you correctly said. Obviously, just quickly recapping, the first thing that happens is an event or circumstance arising giving rise to a claim. First thing the contract has to do is to give notice. You've got 28 days to do that. And then it's got 42 days, that's 6 weeks, to give its particulars. And then we've got this provision that's on the screen at the moment, that the engineer has got 42 days in which to approve or disapprove. And then thereafter, it appears that the engineer will go on to make a subclause 3.5 determination. Now, what I always got confused about was the nexus between the approval and disapproval stage within that 42 days and the 3.5 determination stage. Because for me, it would seem, particularly as an engineer can potentially ask for further documents from the parties, that that's a two-step process. Although I have heard it said that an approval and disapproval process can merge into the 3.5 determination process. That to me doesn't make any sense. But I wonder whether, Malice, what do you think about that 42-day period? Is this a period in which the engineer deals with the principles of the claim? What is an approval and disapproval?
That's where the confusion lies and was confusing in the 1999 contracts. How far does he go? What are the exact what is the best procedure he could follow? The best practice in trying to reach a point where he will give approval, disapproval, or disapproval with comments. And what does the contractor do after that? Now, 20.1 dealt only with contractor in the 1999 contracts, although the 2017 contract deals with claims from the employer as well. So after the engineer has given some so-called approval, disapproval, or disapproval with comments within 42 days, then does the contractor go and ask for a formal determination under 3.5? So it was a bit of a two-step process. Might not lead anywhere. You might still get the same answer under the subclause 3.5 determination. So there's a lot of confusion as to what should be done. And at the end of the day, was a process followed in proper manner under 3.5? There was talk of, although we practice consultation, and then the engineer trying to reach an agreement between the parties, and if not, to issue his determination or a statement of agreement. There was still confusion what is the exact procedure to follow. So I think that's why I think the 2017 contracts are a bit of fresh air. It tells the engineer exactly what procedures should be followed for best practice in resolving a claim that the contractor or the employer may have submitted, and going through a process in which it's a lot more transparent, it's fair to both parties, giving opportunity to both parties to present their positions. So I believe that 1999-2020.1 process is very loose and doesn't give direction to the engineer on what should be done. One of the things that made a change, I guess, in the 20.1 was with the MDB harmonized edition, which brought in the condition that if the engineer does not respond within 42 days, then it's considered rejected by the engineer or any other parties. And any of the parties may refer the dispute to the dispute board. So where do you go to the dispute board? So the Pink Book, in a way, the banks wanted it that way, and that the engineer does not respond within 42 days, then it's considered rejected, which gave engineer very dicey position, because he might end up, if he doesn't give his opinion or his approval or disapproval within 42 days, he might end up having no say in the claim at all. It'll go to the dispute board. So there was a certain commitment by engineers in the Pink Book contracts to try and respond within 42 days. So I think that was a good thing. But I think most things, problems associated with the 1999 contracts, where it was not sure which way the direction in which the engineer should proceed, was, I think, to a far extent sorted out by the provisions in the 2017 contracts. I hope I answered your question, Tanner.
Yes, thank you. Don, would you like to add anything?
No, I'm fine, thanks.
No. Okay. So I get from what you're saying.
Tanner, closer to the microphone, please.
Sorry, I get what you're saying, Malice, that the 2017 form is, I think you used the words, a breath of fresh air, because we've got a defined period in which the engineer will go through this consultation period, and that is a 6-week period. For those of us who are still using the 1999 forms, do you think that 6-week period, that 42 days, would be a good kind of guide to 1999 engineers doing consultations? Do you think that's an appropriate period for a consultation to take place? Or do you think it's, I mean, I've always wondered how FIDIC comes up with these particular timeframes. I mean, in the Golden Principles, for example, they set out that we shouldn't be messing around with the timeframes. But how is it that the timeframe has been reached? Do you think it's a good timeframe? Is 6 weeks enough? Is it too much? Is it too little?
Well,
Tanner,
Tanner, I believe
yeah,
that the FIDIC 1999, and basically the FIDIC is an international standard form of construction contract, and to a certain extent it seeks to accommodate the fact that the contractor and the employer may be operating from different territories, so you may need a longer time in order to get that through. But the principles of the claim I've always understood to mean that the engineer can actually say, okay, the claim falls within the ballpark. I may not agree with the fact that the claim is time barred, which is being brought by one or either of the parties, and thereby a dispute is created, because when a claim is asserted, it's not automatically a dispute. It becomes a dispute only when there are differing contentions between the parties. That's when a dispute is, and that's where maybe the engineer wants to get a bit more information to make up his mind on the principles, not to actually make the determination. And I really, in Botswana, what has tended to happen is that this in principle determination has tended to very quickly morph into the engineers, because once he's done his in principle determination, he then takes that to the contractor and to the employer separately. And as soon as he gets the fact that there is a disagreement, then he proceeds to do his 3.5 determination. But if there can be an accommodation reached, and a skillful engineer will ordinarily be able to work some sort of a compromise between the parties that is acceptable to them, to the extent that claims for money, you can never get a compromise.
If I may also add, Tanner, I think the 2017 contracts put into words what we have been practicing for decades. A good period of time of consultation, trying to reach agreement, which was always anyway practiced. And what's the way to go about for an engineer to resolve a problem and see whether agreement can be reached with the parties. So after, if consultation is not successful and agreement cannot be reached, then it goes through the process of making a determination. It was not spelled out very well in the 99 contracts, but 2017 contracts gives the provisions for an engineer to act in such a way. What we've been practicing for years. I mean, it's not only for that, for the DAB also. When the DABs DABs now has a whole provision on dispute avoidance. While we practice it for years, for decades, dispute avoidance by a standing dispute board, not very well spelled out in the contract. So there are a lot of things that the 2017 contracts, got into, captured into the contract, which we have been practicing for decades. So I think that's where, as you asked, where did they come from? Yes, that comes from good practice we've been practicing for decades.
Okay, let's take what Don was saying and use it as an example about when a dispute arises. Let's give this example. The contractor presents its claim, and the engineer, and we're talking 1999 here, 99 red, the engineer decides that the claim is time barred. So when it's got the particulars, after the particulars have been submitted, the engineer, within the 42-day period to approve or disapprove, disapproves the claim because it's time barred. So at that point, I wasn't entirely sure, Don, whether you were saying, because the engineer's already disapproved the claim, does the engineer then have to go through a 3.5 process to consult with the parties when it's determined that there's been a time bar? Or can the dispute be said to have arisen upon the disapproval because it's considered it's time barred? So in other words, going back to the question, can there be a referral directly to the dispute board after the engineer has disapproved a claim on the basis that it's time barred? Or is it mandatory for an engineer to go through the 3.5 process before a dispute can arise that can then be referred to the DAB?
My understanding, Tanner, is that it is necessary for him, because the obligation on the engineer acting in accordance with 3.5 is that he shall endeavor to agree or determine, whenever these conditions provide that the engineer shall proceed in accordance with this subclause 3.5 to agree or determine, the engineer shall consult with each party in an endeavor to reach agreement. So that's the first stage. He will have to consult with the parties. The problem comes with 20.1 and the in-principle determination. How far is the in-principle determination? Could it not be said that he has already fettered his discretion by arriving at the in-principle determination, which a party would say it's pointless for him to then go through the formal 3.5 determination when he's already made up his mind? That's my thinking.
That's my point. That's my point, Don. I think that I'd love to throw that to Malice to see what Malice thinks. Because my point is, when the engineer's already made its determination that the claim is time barred, why does it need to then consult with the parties? It's already made a decision. I mean, there's no definition of dispute under the 1999 form. Contractor's made a claim, engineers determined it's time barred. That's a dispute. Contractor disputes the dispute. You know, the way that people used to look at it is claim is asserted, claim is rejected, rejection of rejection equals dispute.
And I think we use the wording. I think we use the wording. A dispute has crystallized is the word that we use.
Sure. So what do you think, Malice? Do you think that the dispute has crystallized at the point of the engineer declaring it time barred within the 42-day period of disapproval, or does he have to go to the 3.5 process?
That's where the confusion was. So whether dispute crystallized usually was decided by the contractor after 42 days and receiving the engineer's approval, disapproval, or disapproval comments or part approval of his claim. He will decide whether he would go for a 3.5 formal determination. And that's what we practiced for years. The contractor decide, am I going to go for a formal determination under 3.5 as well, after he's very clear that he has not approved it, either due to time barring of notice or whatever reason. And I found many times that after the engineer has disapproved any claim, the contractor will proceed to DAB, to the DB or the DAB to submit his dispute referral without going through the 3.5, asking for a formal determination under 3.5. So that's what used to happen. So there's a lot of confusion at that time whether that is the correct path to follow or not. So so that's one of the things that were examined very well, and when we were formulating 2017, and 2017 I think has dealt with it quite well by giving a process for the engineer to follow when a dispute, when a claim is submitted to him. And the claim lands on his table, he has a certain procedure to follow, which is very clear, and giving opportunity to both parties to present their position. So I think that's where the solution lies.
But just getting back to that, Tanner, if one looks at subclause 20.4 of the FIDIC of 1999, it states that if a dispute of any kind whatsoever arises between the parties in connection with or arising out of the contract or the execution of the works, including any dispute as to any certificate, determination, instruction, opinion, or valuation of the engineer. So the difficulty would be if the engineer has not expressly given his in-principle determination in writing, then he can always argue that I've been misinterpreted or misquoted. This is the reason why persons would rather then say, put your money where your mouth is, give me a 3.5 determination.
Sure, but when you read the first sentence of 20.4 and it says if a dispute of any kind whatsoever arises, I think there's a good shot at an argument to say that when an engineer has rejected a claim based on it being time barred, that has triggered a potential dispute. The wording talking about that it goes on saying including any dispute as to is not exhaustive. A dispute can potentially crystallize at the point when there's been a rejection of the rejection. So I hear your point, but I can also see the counter argument that might be presented. But I want to go back to this consultation process, because there was something that I wanted to explore with you both about this, because it's always been interesting to me how the mechanism of the consultation should take place, because we heard from Malice that perhaps there should be 1 or 2 rounds of consultation that takes place with the engineer? I mean, obviously nothing's defined. It may be 1 round is enough. Potentially you can get an agreement reached. It may be 2 rounds is better. You might need more than 2 rounds. Put that to one side. The actual mechanism of what happens in that process is what I'm interested in. Can an engineer, let's use an example again, contractors made a claim for €1 million and the extension of time claim for 6 months extension of time. And the engineer in the consultation process goes to the contractor and says, I've seen that you've got a claim for €1 million and 6 months. I have to tell you, and this is confidentially, only an audience is happening between the engineer and the contractor. Employer's not in the room. I have to tell you that I think your claim has been exaggerated. When I looked at it, I thought the ballpark would be around $750,000, and I think probably 4 months is about right. Do you not accept that? And then the engineer walks into the other room and talks to the employer and says to the employer, look, this contractor's made a claim for $1 million. I think it's exaggerated. I think you should potentially think about paying 750 and perhaps give 4 months. Is that process of talking confidentially to one party and then confidentially to the other party, I think sometimes the word shuttle diplomacy is used. Is that appropriate? What do you think?
Well, to my mind, it can be a bit of a double-edged sword, to the extent that wearing my mediator hat, what one finds in mediation is that when one is negotiating, there is what we call an anchoring offer. And what makes the offer, because now there's a very fine line where perhaps what the engineer is thinking is being ideas which are now being infused to the parties, rather than the parties themselves stating what their position is to the engineer. You could have a solution that either party, after the champagne corks have been popped, it later turns out that the parties finally realize that it's neither of them who has actually looked at dispute avoidance, and it's the engineer who's basically brokered what is in his mind, what we would term in negotiation terms an anchoring offer. So there is that possibility. I'm not saying it happens, but there is the risk that that could happen. Because what I've understood to be the purpose of the consultations is to say, Mr. Employer, we've received a claim from the contractor. Now, what are my thoughts on the principles of the claim? Well, it's not based on any recognized method of delay analysis, for example. So, now the impact, I'm not convinced that the impact on the program is such that it would have taken the time for completion. It would have extended the time for completion. So I don't really think there's a claim there. What do you have to say? And then they say what they think. And he takes the contractor aside and actually objectively gives his technical advice, which is on the principle of the claim, to actually say, look, this is what I think on the principle of the claim. I don't think you've demonstrated sufficiently the impact or whatever it is. And that way, it's a lot better than simply going shuttle diplomacy and saying what the engineer thinks. Because in mediation, you're there to listen more than you are to speak.
If I may also add, Tara, so when a contractor does come up with what he thinks is his logical claim, which might be more or less than what the engineer's logical position is on the matter, somewhat like a called a bank offer in arbitration. Now, if it's less than what the engineer thinks is due to the contractor, then what do you do? I mean, do you need to go and proceed further down the line, trying to convince the engineer's evaluation is correct? He might say, yes, I have understood what the contractor has said. and what you think should be the amount due to you. I hope that I have, I can use whatever you have offered to discuss with the employer the amount that you have offered to settle the matter. So it depends on the engineer whether he would take it as an offer made by the contractor to see whether that could be logically applied, which might be more than what his position is on the matter. So he has to then discuss and with consultation with the employer, see what his position on the matter is and see whether he can reach an agreement without disclosing what the contractor has said in detail. It might solve the matter right there itself rather than go any further into further dispute. So that we have to take advantage of such offers.
If we had more time, I would have potentially suggested that Malice would be the engineer. I could play the role of the contractor. Don could play the role of the employer, and you could see whether or not we would be able to reach an agreement or whether we'd be a swords at dawn scenario. But because we haven't got that much time, I wanted to just potentially, I don't know if we've got enough time, Georgiana, for just another question. So one of the questions that I want to revisit some of the things that we discussed in our previous sessions, which is the interface between the dispute board when it comes to dispute avoidance and the engineer when it comes to dispute avoidance. So we've discussed today about what the engineer should be doing in the consultation stage and how the engineer could potentially procure an agreement between the parties. But how does that interface with the role of the dispute board when it comes to dispute avoidance? And let's look at this under the 2017 form. So in the 2017 form, subclause 21.3 makes it clear that when the dispute board is jointly approached by both parties, it can consider potentially engaging in the dispute avoidance role. And there's a suggestion in 21.3 that this shouldn't be happening at the time that the engineer is participating in the 3.7 agreement and determination process. So what do you guys think? Do you think that it would be appropriate for the dispute board to get involved and potentially interfere with or aid or try and help the engineer when it comes to the possibilities of dispute avoidance? Or is it, because you can agree otherwise in the 2017 form, you could potentially ask the dispute board to get engaged in dispute avoidance at the 3.7 determination phase if you wanted to agree it. But would you think that's a good idea? Do you think it makes sense for the dispute board to be engaging in dispute avoidance at the point that the engineer should be carrying out the 3.7 processes?
Should I answer?
Either of you, but if you want.
Tana, yes, of course, the dispute avoidance role of the dispute board starts long before it has got to 3.5 determinations. The idea of an experienced dispute board is to be able to see far ahead that a problem is coming up, and to bring it into conversation, either at a side meeting or any other meeting, bring it to conversation. And if the parties see that there is a problem and they would like the DAB to give their assistance in solving the matter, that's good enough. And then of course both parties will have to ask. But the DAB should offer to provide assistance and also bring it into conversation. And a lot of problems have been solved because the DAB saw something coming up, some problem coming up very much early before it becomes a claim and a dispute, and be able to resolve the matter. This may be where lawyers might be a bit disadvantaged because of the fact that they don't have construction experience, but engineers who have been in construction for a long time definitely can see a problem coming up. And of course, even under 3.5 or 3.7 in the syllabus, determination done by the engineer, if parties agree and the engineer also has no objection, yes, of course, DAB can intervene to see how they can solve the problem, and they can even put the 3.5 process to suspension or hold until DAB sees whether a problem can be solved. So it all depends. If the parties decide they can, of course, FIDIC contracts say that the DAB should not get involved when the 3.5 process or 3.7 process is working. So, you know, they are there to solve problems. Don?
Well, I think this is the point at which we introduce the train leaving the station, because there is a point at which where the engineer is exercising his 3.5 determination, you don't want that to be fused with or interfered with by the process of the DB exercising its dispute avoidance. And I have come across a particular DB where the DB has been established as a DB, then without actually, this is under the 99. And I think it was all the excitement with the 2017 Dispute Avoidance Board. It was not constituted as such, and they offered to the parties to say, let's reconstitute ourselves as a DAAB, and we'll be able to help you a lot more effectively. But one of the parties was not willing to go along with that, and they said, the train has left the station, we're where we are, let's get on with it.
Yeah, I agree.
If the parties do agree, anything is possible, in my opinion.
Where are we at, Georgiana? Do you think we're almost out of time now, aren't we?
Yes, that's why I've submitted an answer in writing, but just a last question for you guys. Do you think there is a possibility for the engineer to actually be paid jointly by the parties? Is that recommendable? That's one of the questions from Moen Dins Sheikh. Would that solve anything in terms of impartiality and neutrality?
Well, I mean, I can start off if that's okay with you, gentlemen.
Yes, please.
Yes.
So there's a lot of roles that the engineer has, and some of the roles that the engineer has are very much in the interests of the employer, and it's for that reason that in the 1999 form it's expressly specified that the engineer is deemed to act for the employer. So, for example, when an engineer is issuing instructions, the engineer is acting on behalf of the employer when it's issuing instructions. If an engineer is issuing variations, similarly, the engineer is acting on behalf of the employer. So whilst, of course, if the engineer's role was entirely a role of trying to resolve or avoid disputes, so if the engineer's role was confined to 3.5, so only the engineer is only going to be involved in trying to avoid or resolve disputes, then I can see why it might be the idea of potentially jointly paying for that engineer would make sense. But because the engineer's role is so wide and covers other things, I don't think it's appropriate. I think the reason why the 99 form introduced the dispute board was precisely to address the fact that whilst an engineer acting properly can potentially give a fair determination and potentially resolve matters, realistically, there may be circumstances where the engineer is put under undue pressure by the employer and is therefore not able to give a fair determination, and therefore there is a mechanism available to allow a dispute board which is independent, impartial, which is to be paid for jointly by the parties, and so that works. So my own view is it wouldn't make sense, because of the multitude of roles that the engineer has, for the parties to jointly pay for its services.
And I agree with that position.
For me, of course, the engineer's role starts long before even maybe tendering. So before the contractor moves to site. So and the employer may not be technically competent, have personnel to be able to administer the contract. So you have an engineer who acts for the employer. We are in the developing countries, we're quite used to having employers, project management unit quite large, with a large number of people, while repeating quite a lot of the engineer's duties. That's a problem that developing countries have, but that's because of our inbuilt systems. So the engineer's role is actually to be able to provide the contractual and technical input required to carrying out a works construction as best as possible. So he has his role to play, being the employer's agent right throughout the contract. So one of the things that 2017 contracts achieved was to, under 3.5 and 3.7, give him that independence, explicitly give him that independence and impartiality and neutrality to carry out his duties in making a determination in an impartial manner. So I think the role of the engineer in the rest of the contract is looking after the interest of the engineer, because the employer may not have and will not have the technical input and contractual input that is required to execute the project. We in the developing world are quite used to it being a bit different, where the employer's personnel are much larger and then providing and repeating things. But we had to understand the engineer's role is very clearly defined in the contract, and that's the best way to use it. Thank you, Tanner.
Great.
Well, okay. If there are no further questions, then we'll stop here. For those of you who had to go and texted me, yes, I confirm the recording is going to be available both on the DRBF YouTube channel and for the members in the library at any time. Thank you very much indeed to our speakers today, Tanner, Malith, and Don, and I hope you'll join us in the future again. And next week, we're going to discuss climate-related disputes and green DBs with Patricia Galloway and Jeremy Glover. So thank you all for joining us today, and happy Easter to those celebrating this weekend, and see you next week. Thank you very much, gentlemen.
Thank you.
Thank you very much. Thank you. Bye.
Bye-bye.